And sir, for your appearance this morning?
Just 1 second, I was certain that in there. I'm not sure if I even have everything. I apologize for that, man.
It's all right. When you're ready.
Here's third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank?
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached.
Right,
so notify the parties.
Judge.
Yes.
I'm sorry. Oh, go ahead.
No.
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it. It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information. It had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah. If it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial and also any alternatives along those lines, short of that, or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced, because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES. 917 F2D 388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury, which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language is pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of, the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it.
The jury has begun their work deliberating, and you can hear the defendant is asking, sort of, I don't think he formally requested for a mistrial, but he's talking about it.